from alcoholic moms and former sex offenders,
and driving offense. She was drinking during the first trimester of the pregnancy,
and children who refuse to have anything to do with their mother, haunted by her past as a drug
Mackenzie
addict.
and Colton are here. They have written declarations, and I can get those filed. I can get the notice evidentiary hearing filed today if you'd like. But the kids would like their brother returned back immediately.
And don't forget the women living lavishly off child support.
$20 car payment, which is high above anything that defendant owns, and she's residing in a home that she can't afford. She's provided absolutely no proof that she is looking for alternative employment. It seems that she's simply just sitting at home and collecting a paycheck.
The child support system often feels rigged, favoring entitled and delusional women. But stick around to see how these women finally got what they deserved and are now regretting every bad decision. First up, we have a man taking his wife to court, battling for full custody due to her struggles with alcohol, and to make matters worse, her brother is on the sex offender registry.
Offense. She was drinking during the first trimester of the pregnancy.
Court will note the appearance of Ms. McNiff on behalf of defendant, and also appearing in this matter is Mr. Magnuson on behalf of the front of the court. This matter is before the court on the defendant's motion for temporary custody, parenting time, and support. Ms. McNiff.
Your Honor, as the court can see from our pleadings, we have significant concerns about Ms. Kirk's living arrangements. She's currently residing with her family, but that includes her brother. He's also on the Michigan Sex Offender Registry. We do not believe that it's appropriate whatsoever for this child to be residing with him, and he may be breaking some of the provisions of his status on the Sex Offender Registry as well. We also have significant concerns about mom's use of alcohol, given the fact that she has a long history of alcohol abuse. She's had a drinking and driving offense. She was drinking during the first trimester of the pregnancy. She also has significant psychiatric disorders and takes medication for those disorders. Her brother also has psychiatric disorders and is on disability for those disorders. On the other hand, Mr. Duncan is employed full-time. He resides by himself. He's responsible. He doesn't have substance abuse problems, and he has the ability to care for the party's one-year-old child completely. He's self-sufficient financially. We believe that he is the more appropriate person to have the full-time care of this child. So we are asking that he be granted both temporary and permanent physical custody of the child, and that the parties be granted joint legal custody. We would ask the court to prohibit mom from leaving the child at any time alone with her brother, and from residing with the child with her brother. We're also asking that she be required to sign up for SoberLink and to test herself when she has the minor child in her care. Thank you, Your Honor.
Okay, thank you. Ms. Kirk, any response?
I do disagree with some of the information presented. That's all I have at this moment.
Okay. Court does note the court has reviewed the pleadings in this matter. I guess I'll let you chime in, Mr. Magnuson, if you have anything to add.
I would just indicate, Your Honor, that for the record, for the party's benefit, our office does not represent either party in this case. We brought this action under the Family Support Act based on information received from the Office of Child Support, indicated that Ms. Kirk and Mr. Duncan were living separately, and our child was with her, and they were receiving public assistance. And so in the normal course of our duties, we brought this case. I would note that the next step that we would take would have been to set it for a hearing in front of the assigned referee, at which time all issues, custody, parenting time, and support would be addressed.
Okay, thank you. Well, court's heard, I've read the pleadings, court's heard the argument in this matter as well. There is a court's concern. There was an issue in which when the plaintiff was removed from the home by police, that she was originally charged with assault on the defendant. Those charges were dismissed, but that happens for many reasons in this matter. So the court is well aware of that. It does appear that the home environment of the defendant is appropriate for the child in contrast to that of the plaintiff, who has a registered sex offender residing with her. In this matter, there has been some obviously questions as it relates to psychiatric disorders in this matter. The court's taken that into consideration, but I'm not giving a lot of weight to it until we have more evidence on that. But it does appear that the defendant does have a stable home, a stable environment. The court is going to grant to the parties, because Ms. McNiff has requested that, joint legal custody. The court will grant physical custody to defendant father. The court will allow the plaintiff to have standard parenting time and support pursuant to the incomes of the parties. If we don't have any income, then the court will allow Ms. McNiff to impute the sum of $15 per hour full-time income to the plaintiff in this matter. The court will, at this point, I'm not going to order sober link at this time, but the court will reserve on that. The court will order in this matter, Ms. Kirk, so you know when you do have the child with you, that the child will absolutely have no contact whatsoever with your brother. You understand that?
Yes, Your Honor, I understand. I live with my grandmother.
Okay, that's fine. I'm just saying, so if your brother were to come over to your grandmother's and you're there, you have to leave or he has to leave, because it would be a violation of the order. If the court finds that you are in fact allowing any contact with him, the court could terminate all of your right to have parenting time. You understand?
Your Honor, I understand.
Okay, thank you. Ms. McNiff, I'll let you prepare the order, submit under 7-day notice of entry, and that will conclude this matter.
I'm sorry, Your Honor, did you intend to prohibit alcohol when the parties have the child?
I didn't, because you didn't ask that. So
Okay.
you just asked that Silver Lake, but
Okay.
The court will have.
So on the next case, the kids don't want anything to do with their mom, but she took them forcefully and got arrested.
I'm going to say this one more time. If
I
the
do
child's
understand.
not at Lexington Elementary tomorrow, I'm issuing a warrant for your arrest. Is that clear to you? Mrs. Yusanovich, where are you on this?
We are adamant that, Mickey and Mackenzie and Colton are both right here with me. They have written declarations stating they do not want to go back with their mother. We were at a point where the last time we saw Commissioner Nelson, we were going to continue with the evidentiary hearing. However, on October 8th, Tesla came into my home and took Braden. I was not able to get on the phone. We kind of live out in the country, so I wasn't able to contact 911, which is a whole nother issue. But once the sheriff did arrive, he said that because Commissioner Nelson did not put in writing on the minutes that I had that the children should stay in my custody until I filed the evidentiary hearing, to continue it, that there was nothing they could do to uphold it. So that it basically, they couldn't go get Braden back. However, I am requesting that we continue with the evidentiary hearing. Again, Mackenzie and Colton are here. They have written declarations, and I can get those filed. I can get the notice evidentiary hearing filed today if you'd like. But the kids would like their brother returned back immediately. He was going to school here at Lexington Elementary, and then I got a call on Monday or Tuesday saying that she was trying to put him in Columbia Heights Elementary. So they had questions about that. I don't know if Braden went to school yesterday or not, but upheaving him from his home, and these kids have been here since last December.
Okay. Hang on, ma'am. Hang on.
Yeah.
Ms. Smith, are you there?
Yes, I am.
Oh, Mallory Smith.
Matt.
Good morning, Your Honor.
Good morning. Have you been able to do any work in this case?
Your Honor, I have met, and I apologize, I have limited bandwidth right now. I have been able to meet with the children in this case and with Ms. Yozanovich. I've had conversations with Ms. Ivy as well. Father's been pretty avoidant of this matter in totality. It would be my recommendation to the court to consider Ms. Yozanovich's preference right now. The children have expressed a desire to remain in Mr. Yuzanovich's care. It's been a consistent and stable home. I'm proud of Miss Ivy for pursuing and maintaining sobriety. She indicates having 6 months clean and attending meetings and participating in those things. The children unfortunately have a long history of just living in influx while in Miss Ivy's care. So their concerns are valid. They do want to remain connected to their mother, but they are just in a place right now where they do appreciate and are feeling much more stable and able to participate in schooling and extracurriculars and those types of things while in the care of Ms. Yuzanovich.
Miss Ivy, what do you want to tell me?
Your Honor, I do have my son in school.
Where?
At Columbia Heights Elementary, and he's doing very well. I've got him potty trained because he wasn't potty trained. He's happy with me. He does want to live with me.
That's funny.
Okay. I don't want any schools changed. So whatever school he was in last week is the school he's going to be in going forward. Understood?
Then
Yes.
that would be Lexington Elementary. That you mean the school that he was originally.
Ma'am.
Yeah.
Miss Ivy, do you understand what I'm saying?
Yes, Your Honor. He likes it at Columbia Heights.
Ma'am, do you understand what I'm saying? The child's going to be in the school he was in last week. Period. End of conversation. Do you have any question about that? Miss Ivy, do you understand me?
Yes, Your Honor.
And that happens tomorrow. You understand that?
The same school he's in now, because he's doing
He
really
goes
good.
to Lexington Elementary tomorrow. Do you understand that?
How is that when he's already
Ma'am,
going to Columbia
ma'am.
Heights?
Do you understand what I just ordered? Yes or no?
I understand what you're saying, but he's
I
right
don't,
here.
ma'am, this is not up for discussion. This is an order. He will
I'm
be
not-
at Lexington Elementary tomorrow. Do you understand that?
They told me though that because of where he lives with me, that he couldn't go to Lexington.
Ma'am.
I think that's the only reason why I changed.
I'm
the
going to
school.
say this one more time. If
I
the
do
child's
understand.
not at Lexington Elementary tomorrow, I'm issuing a warrant for your arrest. Is that clear to you?
I said I understand what you said.
Is that clear to you?
Yes.
All right. That's number one. Number two, we need to set a hearing date immediately. So we're going to set a hearing on this matter for next week at 11 o'clock. It will be the last case on this calendar. I want it to be in person here at the courthouse. It'll be the last case on this calendar. It should start no later than 11 o'clock.
Okay. And do you want Mackenzie and Colton to be present, or are the declarations going to be sufficient for
No,
you?
I don't want the kids present in person. I just want the adults.
Okay.
And Ms. Smith, are you available then?
Yes, Your Honor. And to confirm, this is for trial assignment or for evidentiary hearing?
This is going to be an evidentiary hearing on the original petition.
Okay, thank you, Your Honor.
All
And
right.
then, Your Honor, I just have one question. So is Braden going to stay in Miss Ivy's care, or is can I pick him up from school tomorrow when she takes him?
Next up, we have a woman living way beyond her means, staying in a home she clearly can't afford. All while still being unemployed, the plaintiff is now pushing to cancel the payments.
$720 car payment, which is high above anything that defendant owns, and she's residing in a home that she can't afford. She's provided absolutely no proof that she is looking for alternative employment. It seems that she's simply just sitting at home and collecting a paycheck. Plaintiff had an extramarital affair.
The court will note the appearance of Mr. Todd on behalf of the plaintiff, Ms. Capture on behalf of defendant. We have two motions. We have plaintiff's motion for spousal support and other defendant's motion for exclusive use of property. I did have one question, and maybe you can enlighten me in this particular matter. Mr. Todd is okay. Hold on. Sorry, I miscaptured. Where there was this $29,000. I saw all the pleadings, and there was supposed to be a division of this account, And then it was quite confusing over what happened. Was it divided, and does half of that still exist someplace?
Yes, Your Honor, it was divided. My client has his half of the monies, and then the other half, had informed me that Miss Doubleday might not have access to the account that it was originally transferred to. However, the money was, her half of those funds was transferred back into that joint account and still reside there.
So it's in the joint account. She has access to that account, correct?
Yes, Your
Okay.
Honor.
Well, the court will order that she's entitled to receive and access those one half of those funds. It was in the amount of $29,200.11, and so that will be available to her. With that, Mr. Todd, you can proceed with your motion.
Thank you, Your Honor. Your Honor, would you also like me to address the exclusive use as well?
Yes, go ahead.
Okay.
Well, I've received your response, so I know what you're arguing.
Okay, and I'll just limit it to that for exclusive use. We are requesting that continue, or otherwise Mr. Doubleday be required to move the tanning bed and provide a printer for Miss Doubleday to use. In relation to the spousal support, it has been the status quo since April that the parties deposited their checks into this joint account. And then these set bills would be paid out of the joint account. Plaintiff only gets $1,250 net bi-weekly. Mr. Doubleday's income is approximately 2/3 greater than that. In the answer, I believe that it's indicated that Mr. Doubleday, in essence, would continue to pay half of the mortgage, half of the insurance, half of the taxes, half of a phone, half of a car insurance payment. I believe that is, in essence, the answer. However, even when you factor in that, there's still a $600 deficiency for my client's fixed expenses. We believe from a pragmatic standpoint, it would make more sense for Mr. Doubleday to simply continue the status quo of depositing the $21 per paycheck, which he has been, into the joint account, or alternatively, that he be required to pay because his income is 2/3 greater. Ms. Doubleday has been trying to find other employment actively, but has not been successful in doing so. Additionally, the defendant will argue that he's paying $1,500 for an apartment. That is an apartment to his sister. Today, as of today, again, I reviewed everything. There are 3 2-bedroom apartments for less than $1,000 in Marshall, and there are over 15 2-bedroom apartments for less than $1,000 in Battle Creek. So we believe that this is a inflated expense. And from a pragmatic standpoint, that the status quo should continue. We did need to file this motion because originally Mr. Doubleday did in fact remove that $30,000, and Ms. Doubleday did not have any way to access that. Subsequently, we filed the motion, and it's my understanding that there has been half of the money returned to that joint account, but that was not prior to us filing this motion.
Please move on, Mr. Todd. I don't care.
That's all.
Right now.
That's all.
Okay. Ms. Capture.
Thank you, Your Honor. As we stated in our answer to plaintiff's motion, defendant has been paying for his portion of the marital bills. We have offered multiple alternatives for plaintiff to no longer reside in the current home that she's staying in. We've asked to sell the property as it is beyond both of the parties' current expenses. So at this point, any deficiency that is in plaintiff's budget has largely to do with the fact that she has a $720 car payment, which is high above anything that defendant owns, and she's residing in a home that she can't afford. Furthermore, Your Honor, she's provided absolutely no proof that she is looking for alternative employment. We haven't seen any resumes sent into any kind of like work requests. We have absolutely nothing other than her word. It seems that she's simply just sitting at home and collecting a paycheck. Again, Your Honor, if they're asking for spousal support, there is a particular way to request for that. The statute is very clear. There are 14 factors according to Olson v. Olson. None of those have been enumerated within their motion. Your Honor, this simply is not a spousal support case. There's no real need here. Plaintiff lives beyond her means, which is clear, and she has simply not looked for alternative work. Defendant continues to pay all of his portion of marital expenses, plus the new expenses that he has by living in a new location. We attached the rental agreement to our answer. That's very clear that it is a complete rental agreement through RE/MAX. Yes, it is through defendant's sister and brother-in-law. However, it's a fully furnished, completely renovated carriage house in Marshall, Michigan. It's a nice place to live. He has a rental agreement, and these are his honest expenses. So, Your Honor, the request that defendant be required to pay 2/3 of this expenses is just a bit outrageous. Lastly, Your Honor, the exclusive use, as is plain in our answer to defendant's or plaintiff's motion for spousal support and other relief, plaintiff has unfortunately disrupted the business a fair amount. Plaintiff had an extramarital affair that has interfered with employees at the clinic. Many employees are very uncomfortable with the situation that has arisen. The last 2 times that plaintiff has appeared at the clinic, employees were at the clinic at that time. The most recent event, police were also involved. Plaintiff has taken supplements from the clinic. Any other documents or computers that she has access to are completely unknown because she shuts off the cameras. She states she's doing that because she wants to tan, but that seems a little bit unsure. We simply just don't know because she's messing with the cameras. Your Honor, we're asking that defendant be granted exclusive use of the clinic, as plaintiff has no reason to be there. If she wants to tan, she can pay for a tanning membership at any place. She does not have exclusive rights to use the tanning machine after hours. And Your Honor, we are asking that the status quo be maintained. Defendant continue to pay his marital portion of the bills, and that plaintiff also be required to pay her marital portion of the bills. Thank you, Your Honor. I have nothing further.
Thank you. Well, what the court's going to do in this matter, the court's heard the testimony. I've already addressed the account, so that can be put in the order. The court is going to order that the defendant would continue to pay 1/2 of the mortgage, taxes, insurance, and the car insurance in this particular matter. The court would grant to the defendant exclusive use of the chiropractic clinic, and I'm not going to award spousal support at this time. I believe, obviously, with the funds that she has from the $29,000, the child support that she's getting and him contributing towards the marital expenses is sufficient, and the court's not going to award any more money in this matter. Mr. Todd, you can prepare that order, submit under a 7-day notice.
Thank you.